This bill would have a very significant detrimental impact on the public's ability to understand what state and local government agencies in California are doing. And it would do so by raising the costs. It would do so by extending the time that government has to respond. The third and probably most problematic element of this bill is that it would allow government agencies to haul records requesters into court for the mere act of asking for public records.
Welcome to Chicago Justice Podcast. I'm your host, Tracy Siska. I'm also Executive Director of the Chicago Justice Project and Adjunct Instructor in the Department of Justice Law, Criminology, Security at American University. Today we are focusing on the state of California. To California's Freedom of Information Law, open records laws, called different things around the country. Our guest is Sean McMorris, the Transparency, Ethics, and Accountability Program Manager at California Common Cause. So I try to teach my students this. I taught at the University of Illinois Chicago, and during my grad school days, taught as a visiting at the University of St. Francis. Now I'm teaching adjunct at American University. Whenever you enter the playing field of legislative change, update, adjust, get rid of, whatever you're doing to open up that avenue of pursuit, you have to make sure you have the ability to win it, a realistic chance to win it, and the ability to control it. Now, what does that mean? You're opening up a can of worms when you go to add amendments to any law if you can't control the political playing field. Because if you're not, most likely people that are against your updates or against whatever issue you're for, in this case, transparency, are going to seize the day. If you're not winning, they're going to win. You have to be able to have the ability to not only get yours passed, but at the worst case scenario, not allow them to take steps backwards in whatever you're trying to get passed. In this case, transparency. This case, this Assembly Bill in California 1821, it's going after some things that make sense, which is, does government have a role in curbing the current level of data brokers that are out there, but also limiting the expansion of that, where these data brokers are taking government data, turning it into useful information for people, and then selling it. One could argue the government should be, if that data is public, they should just be making it public regardless. So that's understandably what some of the people are trying to manage and control and have a role in trying to make it better for average people. But the question really becomes, can the government be trusted to do that? Right? Because whenever you get into government trying to withhold data from the public, such as they are kind of in what's happening now in California with this bill, it's like you always think like, hey, is this really about, protecting people, or is this about corruption, protecting your political friends and allies? Is it about covering up data that makes you look bad? What's going on? And kind of in America, it's hard to ever think of a time where government's trying to restrict public access to stuff and it really being in the public's interests. It's almost always in their interests. This podcast is typically about policing and the justice system and accountability and transparency. We're focusing on this because it gets very important, as you'll see as we talk to Mr. McMorris. There's some kind of creepy Trumpian things going on with this bill, right? You have to tell people, the government, there's aspects of this bill at times, because it's changed many times, where you had to, when you filed your request, you had to tell the government what you're doing with it. We, as a nonprofit, we have always been able to say, hey, we're a nonprofit. We're not about making profit off this data, but we're about pushing issues and making data available to the public so they're more empowered. That has always gotten us by, because for the most part, there's always two levels. It is, journalism and nonprofit work, average people, and then for-profit corporate requests, which have always cost more. In Illinois, and I think in DC and Maryland that we've done this, and we FOIA in a bunch of other states now, there's always been that two-tier thing. Is this for research or journalism, nonprofit status, or is this a corporate thing? Corporate things always cost more. Now, again, one could say, hey, the government has a responsibility to keep the data in the most efficient manner possible so it can be readily downloaded and made available for the public. Or maybe it should just about all of it should be online anyways. But you get, and we've confronted this everywhere we go. We have confronted in Chicago and Illinois Department of Corrections from the appellate court now in Illinois. We still have a lawsuit in DC. They're complaining about, well, we can't access it. It costs too much. It takes too much time. Costs too much. Wait a minute. You're in control of the data. You have to maintain it a way that's easily accessible. If you don't, it's not our fault. That's your fault. You got to do something to correct that. Don't charge me tens of thousands of dollars for stuff because you hold it in a bad form. That's not our responsibility. That's yours. So I don't know if you can actually trust the government to, say this needs to be withheld and it's always in the public interest. I don't think that's true. We need states, counties, cities. We need there to be a massive rethink about how the Freedom of Information Act works. We're going to have stuff coming up on our website and through the podcast about that, so I'm not going to let that all go now. But this way we're currently doing, even in 2026, is still a massive failure. Okay, let's get to our conversation with Sean, and I'll be back with you after. Sean McMorris, thank you so much for jumping on the pod. We really appreciate it.
Sure, it's great to be here.
So we're talking about California Assembly Bill 1821, which is about the Freedom of Information Act, or FOIA. What was originally in this bill when it first got introduced? And why is there so much discussion and controversy about it?
Yeah, so AB 1821, which was authored by Assemblymember Pacheco in California, first off, it was a bill that, well, it still is a bill that will amend the California Public Records Act, which is probably it is one of the most important pieces of legislation in California. It really outlines, public access to all kinds of information. It allows them to participate more robustly in government. It's a very long piece of legislation. At times it's technical, but it's extremely important. And the underlying premise is the public has a right to know what their representatives and their government is doing. There's all kinds of exceptions for, in terms of, personal information or medical records, all of that stuff. But in general, and courts have broadly construed that this act, the Public Records Act, has to be broadly construed in favor of the public's right to know. So this AB 1821 would have amended that bill, and it's been in multiple versions, as you stated. Originally, the bill was introduced in February. It was essentially a placeholder, making some non-substantive changes to the Public Records Act. Its first substantive version was introduced in March, which would have allowed agencies to charge requesters for staff time after a request exceeded 2 hours or after a requester accumulated more than 10 hours in 1 month. So it also exempted journalists from this and research institutions from being charged this fee. Those fee provisions were later removed, and the version that passed out of the Assembly, in California we have an Assembly and then we have a Senate, and they have to get through both houses. The version that passed out of the Assembly was much narrower. It primarily it just changed the response time of an agency to fulfill a public records request from 10 days to 14 days, basically business days instead of just regular days. So it increased the time there. So basically, and then later it got to the Senate, it changed again. Essentially, I look at this bill as it started out as just an unnecessary bill, and then it became a bad bill, and then it became a less bad bill, and then it went to the Senate and became a very bad bill, and then out of Senate committee it's now a less bad bill. So multiple versions.
And you read her bio, and I'm going to quote from it. A daughter of a nurse and a public school bus driver in a working class neighborhood, Blanca's upbringing, Assemblymember Pacheco's upbringing, instilled in her an appreciation for hard work and the importance of community. You read that and you don't get from that, and maybe this is politics, I don't know, you don't think that's someone who's going to shut off government to average people. Did her bill get hijacked? Or is this kind of what she wanted all along? Is she an active participant in what's going on?
Yeah. So, um, I can't really, state, you know, whether she's, I mean, obviously she's an active participant in this bill. It's her bill. She's the author. Typically, what happens when bills come to fruition are an organization, a group, a person, someone comes to the author, which is either a state senator or an assembly person, with an idea, and usually also a rough draft of a of that idea to implement into a bill. And that author, based on kind of their values and their policy goals, are going to say yes or no to that bill. So Blanca Pacheco, she came through local government. She was previously on the Downey City Council, which is a city in Southern California. It's in LA County. So she kind of knows what goes on with public records requests. She's sympathetic to government agencies that deal with public records requests. I would say Downey in particular is probably, I think, a city over the last decade that they've dealt with this issue. I think it's been known a little bit more than other cities. So I would say she's sympathetic. She sits also on the local government committee in her role as an assembly person. So she gets the local government process. She's sympathetic to it. She's also an attorney, that's well versed in municipal law, and I think all of that resulted in this being generally a policy area that she feels very strongly about. That said, the people who essentially crafted the bill, brought the idea to her, formulated the language, were basically these organizations that represent local governments, and that is the League of California Cities and it's called CSAC. I'm forgetting the actual what the acronym means, but essentially they represent county governments, and so she worked with them on this bill, and they were what I would call the sponsors of the bill, the main drivers. They're responsible for testifying with her during these committees about why it's needed, gathering information to prove that this is a real issue and how it's not going to adversely harm the public. At the end of the day, it's the author's bill. They get to pick and choose what goes in to that bill, and what amendments they're going to take when it goes into and comes out of committees. So, and I'll just note, because I think it's relevant context here, that Assemblymember Pacheco is also the chair of the Assembly Rules Committee, which essentially assigns bills to different committees to have a hearing. And this year, she blocked two other transparency bills, AB 2557 and AB 2063, from even getting a hearing. Uh, you know, and those bills, what they would have done, they would have published on the legislative website, the actual web page of a bill, the written letters that come from lobbyists that go to these committees advocating for a certain position or changes to bills. And those bills didn't even get a hearing. And I bring that up because Common Cause was the sponsor of one of those bills, and we were at least expecting a hearing. So take what you will of that, but that was another instance of, a bill relating to transparency that we feel, um, you know, her involvement resulted in, us not even being able to engage with the public on why this transparency is needed. So, you know, what concerns me isn't simply who authored the bill. It's that this proposal reflected years of frustration among some local governments and who deal with Public Records Act. Rather than investing in better records management or proactive disclosure, or modern technology, the solution in this bill was to make it harder, slower, and more expensive for the public to obtain information. And that's kind of the debate we're having here.
Yeah, I mean, well, what you just said tells the story, right? If she was pro-transparency, there would have been a hearing on those bills. She obviously is not, and that's plain and simple. So that explains a lot. What are the justifications? Well, let me back up. I want to comment on something you said, and I can't agree with it more because we do a lot about transparency. It's Chicago Justice Project. People think crime and violence and accountability. This is what we do, but we're also we use the Freedom of Information Act, Open Records Acts to set up litigation to sue to make data available. And it's 2026. I am sick and tired of hearing about burden. It is 2026, go digital. I mean, but I can't tell you how many times the idiots that we sue show up in court and their dumb lawyers talk about, well, we can't, that's too much work to get that field out of the database, Your Honor. No, that's why you went digital, so it would be very easy. So these local governments need to be forced into going digital as much as they possibly can. Everything should be digital. In Illinois in 2010, when they redid their FOIA in Illinois, they said it's the obligation of the public body to store their records and maintain them in a way that makes them accessible. They cannot use burden because they have an antiquated system. They still do, and because Chicago's court system, the Cook County that oversees Chicago, is so corrupted with how judges get elected, it works. Judges let them say, oh, it's okay if it's analog, we don't care, and that's a burden. That really annoys me that they're still being able to pull that in 2026.
Yeah, I couldn't agree more, and this is the fight we've been fighting in California, and mostly unsuccessfully in terms of the answer. First of all, we will acknowledge, we recognize that with the advancement of technology and artificial intelligence, it's made it much easier for the public to make these public records requests. But that's a good thing. Okay, so if that results in an uptick in these requests, then it behooves these jurisdictions to invest more in fulfilling these requests. However, in my experience, never, do we see a local jurisdiction saying, when they talk about their budgets, and budgets are value based. How you allocate your money in a city or county budget is based on essentially the values of your representatives. And so you're going to dole out some to fire, you're going to dole out some to police, you're going to your employees at the county and state level. But I've never heard a county or a city strongly advocate, hey, we need to invest more in, public records requests because we're getting an uptick here. It's only ever, you know, complaining about the burden, as you said, and there. So it comes down to, in my opinion, values and how you want to invest your budget. If you think that public access to government information is important, then you can set aside more money in your budget to either hire more employees so that you can fulfill these requests, or, like you said, the ideal thing is to invest in the technology that would allow you to find these requests and distribute them much easier than you currently do. One thing that's very simple that wouldn't even involve AI is you just store most of your records in electronic databases. That should have been done a long time ago. Now, I'm not saying all jurisdictions don't do this, but a lot of them don't just because they've neglected it. And so now the solution for them is, oh, let's charge a fee to the public. Let's chill, you know, the public records request process by threatening litigation if we think that your request is overly burdensome. That is absolutely the wrong direction to go. We acknowledge that they may have a problem. We think there's other ways to fix it. And like I said, some of the, um, one of the arguments in favor of AB 1821 was that there are certain agencies that are getting these massive requests from AI companies to essentially so that they can just scrape all these records and essentially create software and sell it back to agencies so that they themselves can fulfill these public records requests more efficiently. Well, yeah, see the irony there? They're upset about these records requests, but at the same time, they could be using the same technology to help fulfill these records requests. And I understand it's not as straightforward as I found a document, let's give it to you. Sometimes you often have to have your lawyers look through it to make sure there's nothing in there that can't be disclosed. But again, technology can help you flag those areas, and so they need to start thinking about, um, you know, investing in how to deal with these public records requests as opposed to burdening the public further or charging the public to deal with these requests.
Right, and it is pretty funny. You got to admit. Wait, some of the burden has been reduced into filing requests. Oh, wait a minute, we're getting a lot more requests. So there is a demand for this information. Let's put up more hurdles. That was their response. Instead of realizing, hey, do an annual thing every year. Go through the requests that you get. What are the most popular requests? Okay, great. That data has to go online in 3 months. We'll see. We'll check back in 6 months to see, after we put that up, we'll check back in 6 months and see what requests come in and what's the most popular. We'll prioritize that data. I think government should be forced to just move towards having as much as humanly possible online. And if they want to fight for some things being secret or withheld, that's fine. Have them do that. Have them produce what they're going to withhold. Have it go into the General Assembly. Have it go to the public. Maybe the Attorney General weighs in. Then it goes to the courts. But it should be a small, very small subset. And with technology, you can filter out a lot of that data. What are the people who support these changes? What are they saying? What is Assemblymember Pacheco saying why these changes are needed?
Yeah, I touched on it a little bit already, but supporters argue that agencies are being overwhelmed by increasingly large, repetitive, automated, or bad faith requests. They point to AI tools that can generate requests to scale, commercial actors seeking large data sets, and occasional like pranksters who abuse these requests. So I think they cited some this one lone example of some kind of a bad faith actor who simply, and he made his intentions known. I want to clog up the works at City Hall, and I'm just going to make these ridiculous requests for all of this information that's going to take you months or years to get to me. And by the way, there's already laws that allow agencies to deal with requests like that. But that's what they're citing. That's why they say that this need is here. And then, they also say that taxpayers should not have to, subsidize these requests for private profit or requests intended simply to overwhelm the agency. And so that's why they're saying, okay, we need to implement these laws to deter these bad actors, but also to alleviate our burden or help pay for the cost of doing this, as opposed to allocating the money in the budget. We're gonna make the public pay for these things that they have a right to access. So, our response, California Common Cause, as well as dozens of other organizations to this bill was, like I said, we recognize that some agencies face legitimate workload problems. The disagreement is over the remedy. Existing law already allows agencies to resist these truly, unduly burdensome requests. And it also allows them to obtain fees in litigation when a request is frivolous. The answer should be, like you said, better records management, proactive disclosure, targeted solutions, not weakening access for everyone. And I'll just note, in some of the testimony in favor of this bill, like some of these outlier examples were utilized, kind of these, cherry pick. And we don't. There's no data. Part of the problem is too, this bill was so rushed, and I don't know if it was because it was intentional to cram it through, but I'm not aware of any data on jurisdictions across California that would, give us an idea of, the extent of this over, the burden or the increase of public records requests. I'm sure it exists, but we don't have that data. We also don't have any data on how much California jurisdictions have invested in, modernizing and streamlining their public records request protocols. So all of that is relevant information when you're going to make massive, significant changes to one of the most important pieces of legislation in the state. And I would say, it's foundational to democratic institutions. It's the public's right to know and participate in government. So this was essentially this bill. I have often described it as, a meat axe that really required a scalpel. When you're dealing with a law like this, there's going to be all kinds of unintended consequences that you're not always going to even realize until the bill's already passed. So you need to take the time to reach out and engage with interested parties, people on both sides of this argument, and think about not only what a proper solution is, but what the possible, consequences and collateral effects of those changes might have down the road.
Yeah, we've sued in Illinois, in D.C., and in Maryland, Prince George County, Maryland, all criminal justice related agencies. And 201, it's the same arguments across jurisdiction, across level of the criminal justice system, across state, the District of Columbia, the Maryland, the other state. They all cry the same thing, and they're all in the some state. And I call it this. And if we can't know, then you can't hold us responsible for not knowing, because we couldn't have known, even though we're the ones keeping the technology so bad and keeping the records in such poor shape that we couldn't possibly know. Now, we're doing it on purpose, but since we can't know, you can't hold us responsible for not knowing. There's this eternal way of thinking, I think, when you get hired into government agencies, that you always have to cover up at all times, even the simplest requests. I've requested, I had a lawsuit against the Chicago Police Department. They gave us a document that didn't really fit in discovery that didn't really fit what we were talking about, but it was something that I ended up wanting. So I FOIA'd them for that document and other documents similar that they created throughout the years. We never had such a document. We've never created one. There are no records. How is that possible? You gave it to me in discovery. But we came across that same thing against the police department, the prosecutors, the Illinois Department of Corrections, the police in DC, the police in Prince George, Maryland. They all say they don't have, whether they have or they can't know, and it's all such a burden. It's very, it's very frustrating. There in a column, I think, and it was in the LA Times. It was in the LA Times. I read a column where you're quoted, and you're going to have to correct me because I don't know if I'm 100% off on exactly where it is the bill is right now because it's amended and changed so much. But this bill would shift the paradigm to make the public prove why they need the information. And that quote scared the living daylights out of me. And I'm in my thinking of cover up and corruption and misconduct in government. Is that being done, or was it? Because I'm not sure if it's still in the bill. You can tell us, but is that being done so that they can treat requests that are about them or their political allies differently than they're going to treat requests that might be about information that are about their political rivals? Or is this strictly trying to separate commercial versus non-commercial requests?
Well, that's the problem with the bill. The previous iteration of this bill, just briefly, because of the intense blowback from the public, the press, organizations like California Common Cause, the First Amendment Coalition, it ran the gamut. Dozens of there were probably at least a dozen op-eds and or editorials against this bill when it came out in the Senate version, which was the really, really bad version of this bill. And one of the things, so what it did in that version is that it came out of the assembly simply extending the amount of time that an agency had to respond to a public records request from 10 days to 10 business days. And then they get extensions if they need it of 14 days. And that went from 14 days to 14 business days. Now, one thing I'll just note here is that agencies don't really need that extra time because even though they have an extension of 14 days, there's no limit in the law that says that they can only make that extension once. They can unlimitedly make that 14-day extension, and they often do. But besides that point, jurisdictions often just ignore that deadline. There's all kinds of stories where someone made a public records request and they didn't get it until 5-6 months later. So this idea that they need more time, it doesn't really pass the smell test for at least members of the general public, because that part is just generally ignored anyway in a lot of instances. But what this bill also did when it came out of the assembly and made it into the Senate was it introduced this idea of commercial fees or commercial intent, which was very vaguely defined, which would have essentially said that if your public records request has anything to do with helping you make money or part of a business, then we can charge you two separate fees: a $22 administrative fee and a $66 per hour, and a $66 some other fee. I can't remember what it was. So I mean that fee structure. One, how do you determine what a commercial request is? That was not defined, and I can get into that in a little bit. But the other part it did was it said that if we think that your request is malicious, we can take you to court and sue you. So it's doing multiple things here. It's letting the government agency decide who is making a commercial request, and it's also which essentially comes down to intent. They're getting this. They're asking you, why are you making this request. And that was part of the bill. In order for them to determine whether you were making a commercial request, they had the right to ask you, what is your purpose for making this request, which is absolutely antithetical to the California Public Records Act. You know, and so you would have had to provide information about yourself, you know, and you could have been scooped up anyway if they thought that, you know, you were going to be using this in some way to make money, you know, as a journalist, maybe, even though there was a journalistic carve out. You know, what about freelance journalists? You know, what about someone who is writing, doing the investigative part, but they don't have a publication yet? All of these things come into play and allow the government to now be the gatekeeper. And by the way, we just have to trust them. We have to trust them that if they're going to charge you $100 an hour, that they actually only worked 2 hours and not 24 hours. And so you set up a system where if you want to, you can weaponize the Public Records Act request against your political enemies and make it so burdensome and so expensive that those people are shut out of the government process. And so, you know, to answer your question, this would have set up a system that it would have extremely chilled public records requests in California, and it would have essentially given government agencies the right to decide who gets information based on why they want it. And that is just wrong. You know, and that's a very, very dangerous concept to even be playing around with when you're talking about the public's right to know and participate in government and in a democracy. And so, you know, often, you know, again, a right is not a right is not meaningful if exercising it exposes you to a government lawsuit. And that's what this would have done.
Yeah, you know, I worked opposition research 25 years ago for a candidate once, and I went to go pick the voting card for his opponent, right? Him and his wife, and to see if they had voted. And the guy, you could go up at that point and just walk up to the clerk's office and they would just pull them and show them to you. You can get copies if you wanted. And I looked at them and I said, "Oh, can you double check that's not the wrong, it's got to be the wrong person?" They're like, "No, it isn't." I'm like, "No, double check." He goes, "I don't have to double check. I know why you're here. That's them. It's open. I can't stop you from looking at them." He goes, I don't care one way or the other. I know what you're here. I know it's the election. Those are the right cards." And I'm like, the person never voted. Had never voted in an election before. Was an immigrant, I think Cuban immigrant, had been here for some time, but never voted. I'm like, this election's over. He's like, yes, it is. Right? But that happened because I could get access and the guy couldn't stop me. If I had to tell him, hey, I'm working for a campaign for this congressional candidate, if he didn't like the candidate, he would just said, no, come back, get out. It can't be filtered by the political allegiance of anyone involved. It can't be. I'm sorry, if the government's doing bad, it needs to be out there. If the public's doing bad, it needs to be out there. That is just the way it goes. If commercial companies are finding ways to make money off of this information, then government, why aren't you, one, doing it? If it's malicious, that's one thing. But if you could just provide if public wants to know, put a database out there to let the public know, then there's no need for the commercial company. Right?
Yeah.
You've won the argument early on because you're running them out. If you can give them information you have, give it to them, they turn it into a database where the public wants to pay to get it. It's just mind-boggling that they would do that. But their reaction, instead of just being more transparent and saying, hey, let's serve our people better, let's just close everything off.
Yeah.
Yeah, I mean, and malicious, that phrase caught me, because if there's ever a political turn of phrase, like, I understand what everyone thinks, but unless you absolutely define it to the nth degree, that is going to be misused. It is just going right because a political officer sitting in office and someone requests information about them or their operation is going to make them look bad. They can easily determine it's malicious. And if letting it out is going to really hurt them, then they're better off fighting it to the nth degree on the public's money to stop it from coming out. So
Well,
one quick question. No,
mhm,
I got a few, but about journalists, because you brought that up.
mhm.
How so it carves out for, I would say, legacy media. Let's call it legacy media. As a YouTuber, right? There's a lot of journalists doing YouTube stuff. I think Hassan Minaj. I think there's all kinds of people we could think about. The Young Turks. Are they journalists? Do they qualify? Would they consider it them? And it does, I think, really inhibit organizations like Common Cause, the Chicago Justice Project, my organization. We publish researchers. Are we journalists? Are we academic researchers? If I got funding from a grant to go do this work, does that mean it's commercial because I'm getting paid for it? An academic researcher who gets a grant, NIH grant, or from Open Society or one of them, is that commercial? Can that? I think that's kind of a slippery slope and is kind of shuts down organizations that the politician may not align with.
Absolutely. And first of all, the intent of why someone is making a request should not matter, period. Uh, and I shouldn't have to be concerned about justifying why I want information that is rightfully mine to access. That in and of itself, just knowing you have to state your intent for the information is chilling. It's like I said, it's antithetical to this idea that in a democratic society, the public has a right to participate in their government and have access to information that concerns the public in general. But malicious intent to here, and this is, exemplifies the slapdash way that this bill came to fruition, and the fact that they did not consult with interested actors in this is that malicious intent was thrown in there. It wasn't defined. They kept saying, "Oh, we're gonna define it later. We will define it in a later version of the bill." But regardless of whether you defined it or not, it's a very slippery slope. And I will note that the law already has, some clauses that allow agencies to deal with this type of truly malicious intent that is meant to just clog up the works at a government agency, or is just absolutely ridiculous. Like, I want all of the government. I'm making a request for, all of the government records you have on file. That's just that there's already laws that they can utilize to deal with that. But the malicious intent part of this, it sets up, like you said, a system where now this whole Public Records Act process can be used as a retaliatory tool against your, perceived political enemies. And, journalism, I would say journalists, would be at the top of that list. They are the ones doing the investigative reporting. They're the ones that dig out these records. They make them palatable for the public to understand, and they connect the dots as to why, what's going on is relevant and possibly concerning to the public. And so generally, a government agency, they don't want any bad press. So if a government agency thinks that this information is going to be utilized to expose them in a way that would shine a less than favorable light on them in the public's eye, they're going to use all the tools they can to try and prevent that information from getting out. And there's, like I said, there's various ways they might be able to do that within the law. But now when you say malicious intent, that's in the eye of the beholder. And you've now set up a system again where um, I have to weigh the cost benefit analysis to myself when I make a public records request, knowing that I may be retaliated against or taken to court and have to pay attorney's fees because an agency is claiming that my request is malicious in nature. And so the basically, it also puts public agencies in a position of deciding who counts as a real journalist, and that's deeply troubling because there are. I would say that um, you know this is the, it's kind of an ecosystem. Journalists, they get information in various ways. They get the information from making public records requests. They get information from others who've made requests. They get information from nonprofits who have done research. So, at what point do these terms malicious but also commercial use come into play? Because at some point down the line, any information I gathered from my request, if it is at all used in any way to make a dime, say it's put in a magazine or a publication that you have to buy to get access to, now you're potentially falling within that category of commercial use. But then also, and I want to note this too, because I've made a lot of public records requests in my career. I've worked with some wonderful agencies that work their butt off to get me absolutely everything I need. They help me define what I need. Um, they help me work with understanding the laws, and they do a superb job. But I have also come across government agencies that their intent is absolutely um, to prevent you from getting information, not just because they're lazy, but because they don't want. There's a political motive involved, and some governments more than others um, are run and controlled by the people who are elected on their councils or the board of supervisors. They, like it or not, they often or at times will play they will have undue influence on who gets access to these public records. It shouldn't be that way, but if you have a government agency that's just generally corrupt, they're going to hire a city attorney that goes along and does their bidding. They're going to hire a city clerk that does their bidding. And so you've created a whole culture within City Hall that basically says that with this idea that public records requesters are bad, um, and do whatever you can to frustrate them and prevent them from getting the information they want. And oh, by the way, they can always sue us, but who has the money to sue a government agency? So just, ignore their threats. So this is a very concerning thing. You do not want to give government agencies more tools to retaliate against the general public or to put up roadblocks to information that is rightfully um, accessible to the general public. Because if it's there, it will be used. Not every agency, I would say most agencies, their intent is good. But there are just like there are, bad individuals who want to make, you know, bad public records requests just to burden an agency. There are also government agencies that want to do all that they can to prevent their so-called enemies from getting information that they have the right to access.
So, two quick questions. What has been the role of Governor Gavin Newsom in all of this? Has his office stayed out? Has he signaled anything one way or the other? I'm assuming they think he's going to sign it.
So, one, his role, he hasn't really had a role. So his role, if he does, comes into play later. He's stayed out of the debate, you know, about this bill. It goes through a long process. A bill in California, it starts in a particular house, and then it has to get through that house, and then it has to go to the other house, which let's say this is the Senate. It has to get through the Senate committees. And if there's any amendments made in those Senate committees, it then has to go back to the original house and get approved. And then it has to pass out of the Assembly floor and the Senate floor. And if it gets through all that process, then it goes to the governor's desk for him to sign or veto. Now, what I'll say now is that AB 1821 at this stage, the worst parts of that bill have been removed because of public outcry. What the bill is now is a version of what originally came out of the Assembly, which is extending the time frame that an agency has to respond to a request. Now, my organization, as a compromise, as well as about a dozen other organizations, said, look, if you take out all this extremely bad stuff, we will go neutral on this bill if you just leave in this time extension. We don't like it. We think it's unnecessary. But if that's the cost of getting all of this terrible stuff out, we'll go neutral. So a lot of us went neutral on the bill, and we're not opposing it as it goes through future committees. There are still a lot of organizations that are opposing it. And right now, it is sitting in the Appropriations Committee. That is a very interesting committee because a lot of what happens there happens behind closed doors. That is where bills go to die if they are controversial or they're going to have a very result in a very high budget for the state. And that there aren't really hearings here. Basically, these bills are then just voted up or down, whether they're going to make it through or not. And they don't have to give any explanation as to why. And there's no public debate as to why this bill lives or dies. So what could happen if, depending on how strong, opponents of this bill are lobbying or advocating the Appropriations Committee, it could die there. More likely than not, it will get through because I think that Assemblymember Pacheco is someone that I think a lot of electeds don't want to upset. Bills have to go through her committees as well. So I presume that this bill is going to go to the governor's desk at some point. And I think whether he signs it or not will be contingent upon the opposition that lobbies the governor's office to try and convince him that this bill is not needed. However, because the most horrible parts of this bill have been removed, it will probably get signed into law.
Yeah, I mean, it makes sense, right? At this point, what a journey there. Sean McMorris, thank you so much. We really appreciate you jumping on with us today.
My pleasure. Thank you.
That was Sean McMorris, the Transparency, Ethics, and Accountability Program Manager at California's Common Cause. This idea of having government require requesters to tell the government what they're going to do with the data before they decide whether or not they give it to them, ridiculous. Now, it's like I said in the beginning of this podcast, having hey, is this for commercial purposes? Is there nonprofit journalism research purposes? I think that's fine. That's general enough that it's never hurt us. And I can't imagine it hurting others that are journalists or something. Yes, I think that journalists probably do get the data gets further scrutinized. I know the data we request when people who have gotten requests from us or they look us up, they get treated differently. There's no doubt about it. But telling the government what you have to do, what you're going to do with the data before, like specifically, regardless of whether you're a journalist or nonprofit or academic researcher, a corporation's pretty obscene. It reeks of political bullshit and lazy and corrupt government officials. Because remember, seems like it was government, either unions or organizations that represent local governments that went to Representative Pacheco and said, hey, let's get these amendments to the state's transparency laws going. We're so burdened with these requests. You're so burdened with them. Put your data online. It ends this. And, from our purposes, we just want all the data online. If there's going to be things that are withheld, tell us what you withhold it, and then tell the public, post to the public what you're withholding. And then if we want to sue because we think you're still withholding stuff improperly, that's fine. That's fine. Then we can sue over a much smaller subset rather than we're suing over the whole set and then we have to negotiate down what we're getting. It's ridiculous. Now, on the other hand, there's no denying data brokers are an issue. In Chicago, you can get background check data from the Chicago Daily Law Bulletin. We heard they collected it. I think either LexisNexis did or there were organizations representing LexisNexis type organizations that would collect that data. When you went in the 6th floor of Cook County Circuit Court, the Daily building had a clerk's office in there, and you went on the 6th floor, there were 5, 6, 8 people a day, and this is back many years, that would just do nothing but look at criminal files, pull criminal files all day in civil files, and type in the details into a database. And they're sitting with their laptops. That's all they did all day. The state had it still does, a way to get your data from your criminal data erased, right? If you went through the process, I'm forgetting the name of it now, but it only really applied to data that was obtained through the court digitally. Okay. It did not and could not, because there's no legal basis for it, erase data out of corporate databases where they went into the court files themselves and typed them in. This has been an issue forever that no one's trying to really tackle. So maybe California should get a little bit of a pat on the back for trying to do it, but they need to think a little more outside the box on this, because this seems very way too big government for us, that I have to go in as a researcher and say, hey, this is exactly what I'm going to do with the data. And that I'm sure I'm going to have to sign some kind of form attesting to the reality, right? That this is what I'm going to do. And what if I decide a year from now to do that? I do what I tell them. I have no idea anything else is going to be done with the data. And in 2 years from now, I decide, hey, I'm going to go and I'm going to do B, C, D, and E with the data, or maybe just E and D with the data. Can they come back at me and say, hey, wait a minute, you didn't tell us you were going to do that with the data? It's a problem. We need a much more open government. I mean, one of the ways to kick these people out of the market is to make the data available, or go in with a scalpel, as Sean said, and really tailor and have a public debate about what data should be out there and what shouldn't be, and then tailor really targeted, specific additional exemptions. Now, I don't think we need them. I think half of the exemptions need to go, but that could be done. That is a possibility, but it just doesn't seem like they're interested in that. And it's certainly not what local municipal governments that we have sent requests all over the country from our ShotSpotter project, but throughout Chicago and Illinois, in Texas, in DC, in Maryland. And we have always confronted. It's too much work. It's too hard. Even in the mid 2020s, that's what we still get. It's ridiculous. Okay, ladies and gentlemen, thank you so much for listening. Again, please share with your friends and contacts. We really appreciate you being here, and I will be back with you next week. Thanks for staying with us to the end. If you believe in this work, like this video and subscribe to help us amplify our message. And if you want to be part of the change, check out the links below to support or get involved.